Welcome to Rapid Revision of Law with PJ. Today we will study about the MCQs of CPC. Which one of the following combinations are not correctly matched? A. Res judicata, section 11. Second, res judicata, section 10. Third, judgment and decree, section 33. Fourth, summon to witnesses, section 80. Select the correct answer by using the code given below. Code A 1, 2, 3, B 1, 2 and 4, C 1, 3 and 4, D 2, 3 and 4. Answer is B 1, 2 and 4. Which one of the following cases is related to the principle of res judicata? Option A Satyacharan versus Devarajan. Option B MH Cooperative Marketing Federation Limited versus Indian Bank Bombay. Option C PC Jairath versus Amrit Jairath. Option D all of the above. Answer is A Satyacharan versus Devarajan. Next, Civil Procedure Code UP Amendment Ordinance 2003 relates to Option A Section 105 CPC. Option B Section 103 CPC. C Section 115 CPC. D Section 100 CPC. Answer is Section 115 CPC. Next one. Which of the following is not a rule of pleading? Option A plead the fact and not the law. Option B state the law and plead the fact. C plead material fact only. D plead facts not evidence. Answer is option B state the law and plead the facts. Next one. Where the local limits of the jurisdiction of the courts are uncertain, the place of institution of suit shall be decided according to Option A Section 17 of CPC. Option B Section 18 of CPC. Option C Section 19 of CPC. Option D Section 20 of CPC. Answer is Section 18 of CPC. Next one. All the courts have jurisdiction to try. Option A all suits of civil nature. Option B all suits of civil nature except suits of which their cognizance is expressly not barred. Option C all suits of civil nature except suits of which their cognizance is impliedly not barred. Option D all suits of civil nature except suits the cognizance of which expressly or impliedly barred. Answer is option D all suits of civil nature except suits the cognizance of which is expressly or impliedly barred. Next one. In which one of the following cases it was held that inherent power has not been conferred on a court? It is a power of inherent in a court. Option A Manohar Lal versus Seth Hiralal. Option B Cotton Corporation of India versus United Industrial Bank. Option C Satyabrat Vishwas versus Kalyan Kumar Kisa. Option D Option C Satyabrat Vishwas versus Kalyan Kumar Kishku. Option D Rajni Bhai versus Kamala Devi. Answer is option A Manohar Lal versus Seth Hiralal. No appeal shall lie from a decree passed by the court. The consent of the parties. It is provided in option A Section 96 first CPC. Option B Section 96 2 CPC. Option C Section 96 3 CPC. Option D Section 96 4 CPC. Answer is option C. Section 96 3 CPC. Next one. Under Order 8, Rule 6 CPC, set off may be permitted if option A, the suit is for recovery of property. Option B, set off claimed by the defendant is ascertained sum of money. Option C, value of property recoverable is less than rupees 2 lakhs. Option D, defendant present a written statement of accounts at any stage of hearing of the suits. Answer is option B. Set off claimed by the defendant is ascertained sum of money. Next one. Which one of the following combination are correctly matched? Number 1. Temporary injunction order 19 CPC. Number 2. Sued by the indigent person order 19 CPC. Number 3. Powers of Appellate Section 102 Code CPC. Number 4. Right to file caveat Section 148A CPC. Select the correct answer using the code given below. Code. Option A 1, 2 and 4. Option B 1, 2 and 3. Option C 1, 3 and 4. Option D 2, 3 and 4. Answer is option A 1, 2 and 4. Just a second, guys. Next one. Point out incorrect answer. A decree passed by a civil court can be executed by option A, the court which passed that decree. Option B, the court to which the decree is transferred for execution by the court passing the decree. Option C, any court having jurisdiction concurrent to the court that passed the decree. Option D, either by court A or B is as above. Answer is option C. Any court having jurisdiction concurrently to the court that passed the decree. Next one. A civil court can't issue commission is the following. Case. Option A. Option A, for examination a person. Option B, for examination accounts. Option C, to execute partition. Option D, to execute a decree. Answer is option D, to execute a decree. Which of the following combinations are correctly matched? First, equity of judgment Section 49 and debted CPC. Second, privileged document Section 29 CPC. Third, legal representative Section 50 CPC. Fourth, pauper suits Order 33 CPC. Select the correct answer using the code given below. Code. Option A 1, 2 and 3. Option B 1, 2 and 4. Option C 2, 3 and 4. Option D 1, 3 and 4. Answer is option D 1, 3 and 4. Next. Which section of CPC prohibits arrest detention of women in the execution of a decree for money? Option A Section 55. Option B Section 56. Option C Section 59. Option D Section 60. Answer is option B Section 56. Next one. Section 144 of CPC should be read with. Option A Order 46 Rule First. Option B Order 47 Rule First. Option C Order 47 Rule 3. option D. Order 41. Answer is option B. Order 47, rule first. Next one. Decree holder means any person whose decree has been passed or an order capable of execution has been made. This definition of a term decree holder is mentioned under option A, section 2 of 2 CPC. Option B, section 2 of 3 CPC. Section C. Option C, section 2 4 CPC. Option D, section 2 D CPC. Answer is option B, section 2 3 CPC. Next one. Decree holder means any person in whose favor a decree has been passed or an order capable of execution has been made. This definition of a term decree holder is mentioned under option A, section 2 to CPC. Option B, section 2 3 CPC. Option C, section 2 4 CPC. Option D, section 2 D CPC. Answer is option B, 2 3 CPC. Question is repeated. Rejection of plant is mentioned under option A, order 7 rule 11. Option B, order 6 rule 13. Option C, order 7 rule 12. Option D, order 8 rule 4. Answer is option A, order 7 rule 11. Which of the following combinations are not correctly matched? First, execution of degree section 77 CPC. Second, letter of request section 82 CPC. Third, legal representative section 50 CPC. Fourth, institution of suit section 28 CPC. Select the correct answer using the code given below code. Option A 1, 2 and 3. Option B 1, 2 and 4. Option C 1, 3 and 4. Option D 2, 3 and 4. Answer is option B 1, 2 and 4. Which one of the following case is on second appeal? Option A, Madanlal versus Balkrishna. Option B, Sudhir Ji Angur versus M. Sanjeev. Option C, Saudan Singh versus Daryav Kumar. Option D, Harsat Chimanlal Modi versus DLF Universal Limited. Answer is option A, Madanlal versus Balkrishna. Thus, the summon for service on the defendant can be given to the plaintiff under option A, Order 5, Rule 9A CPC. Option B, Order 5, Rule 9 CPC. Option C, Order 4, Rule 7 CPC. Option D, Order 6, Rule 6 CPC. Answer is option A, Order 5, Rule 9 CPC. Next one. Section 115 of the CPC code provides for the following. Option A, reference. Option B, review. Option C, revision. Option D, appeal to the Supreme Court. Answer is option C, revision. Next one. Order 23 of the CPC applies to the following. Option A, withdrawal of suits. Option B, appeals. Option C, execution proceedings. Option D, all the above. Answer is option A, withdrawal of suits. Next one. Under which explanation of section 11 of CPC constructive res judicata has been explained? Option A, explanation 1. Option B, explanation 2. Option C, explanation 3. Option D, explanation 4. Answer is option D, explanation 4. Next. Section 18 of CPC provides for option A, place of institution of suit in respect of the immovable property where the property is situated in the jurisdiction of one court. Option B, place of institution of suit in respect of the immovable property where the property is situated in the jurisdiction of different courts. Option C, place of institution of suits in respect of immovable property where the local limits of all jurisdiction of courts are uncertain. Option D, all of the above. Answer is C. Next one. A decree may be executed by option A, Tehsildar, option B, just a second, option B, collector, option C, district judge, option D, either by the court which passed it or to which it is sent. Answer is option D, either by the court which passed it or to the which it is sent. Objection as to place of suing shall be allowed in the court for first instance in the essence of option A, section 21A of CPC, option B, section 20 of CPC, option C, section 22 of CPC, option D, section 21 of CPC. Answer is section 21 of CPC. The period of limitation within which defendant shall submit his written statement is ordinarily within option A, 60 days from the service of summons, option B, always 90 days from the service of summons, option C, 30 days from service of summons or 90 days if allowed by the court, option D, 15 days from service of summons. Answer is option C, 30 days from service of summons or 90 days if allowed by the court. Next one. A person may sue a foreign state, option A, with the consent of the state government, option B, only with the consent of the central government, option C, with the consent of the central or state government, option D, with the consent of the President of India. Answer is option B, only with the consent of the central government. Next one. Certain topics under CPC are described hereunder in list first, while their section order number are mentioned in list second. Match the entries and list first and list second and write the correct answer using the codes below. List 1 or list second. Affidavit A, एफिडेविट है, फर्स्ट में ऑर्डर 26 दे रखा है. नेक्स्ट वन B, arrest before judgment and second order 33. I will correctly answered here. Just affidavit order 19, arrest before judgment order 38, commission to examine the witnesses order 26, and sued by the indigent person order 33. If you want to codes, then here are codes. Option A, second, first, third and fourth. Option B, 3, 2, 1, fourth. Option C, 3, 4, 1, second. Option D, 1, 2, 3, 4. Answer is option C. Next one. Under which provision of the CPC temporary injunction are granted? Option A, under section 116B and under section 152C, under section 39 rule first. Option D, under order 29 rule first. Answer is option C, under order 39 rule first. Next one. who can file a suit under the section 91 of the CPC for public nuisance? Option A, Advocate General. Option B, any citizen. Option C, District Magistrate. Option D, any 10 or more citizens. Answer is option A, Advocate General. Next one. The duration of existence of a caveat filed under Code of CPC 1908 is option A, 60 days from the date on which it was filed. Option B, 30 days from the date on which it was lodged. Option C, 120 days from the date when it was lodged. Option D, 90 days from the date when it was lodged. Answer is option D, 90 days from the date when it was lodged. Next one. The period of limitation within which defendant shall submit his written statement is option A, 30 days from the service of summons. Option B, 40 days from the service of summons. Option C, 60 days from service of summons. Option D, 120 days from service of summons. Answer is option D, 120 days from service of summons. The judgment under section 29 of CPC 1908 means a decree. Option B, dismissal of appeal summarily. Option C, a statement of grounds and order or decree. Option D, all of the above. Answer is option C, statement of grounds of an order or decree. Next one. Section 15 of CPC provides provision for the following. Option A, reference. Option B, review. Option C, revision. Option D, appeal to the Supreme Court. Answer is option C, revision. Next one. Match the list first and list second and select the correct answer by using the code given below the list. List 1. We will solve it directly. A, interpret pleader suit, section 88. B, letter of request, section 77. C, precepts, section 46. D, power of order discovery, option 30. Just see the codes. A, 4312. B, 2413. C, 3241. D, 2134. Answer is option B. Next one. Where a compromise was arrived between parties to the suit by playing fraud, misrepresentation or mistake, and a decree was passed with the consent of the parties, then the suffering party may select which one of the following alternatives for setting aside such decree. Option A, through appeal. Option B, through revision. Option C, through review. Option D, through second suit. Answer is option D, through second suit. Next one. The document on which plaintiff relies upon in support his claim shall filed by him in the court. Option A, along with the plaint. Option B, within 7 days from the date of order by the court for issue of summons. Option C, on the date fixed for forming of issue by the court. Option D, at the time or before the hearing of the suit. Answer is option C. On the date fixed for forming of issue by the court. Next one. Under Code of Civil Procedure 1908, which one of the following is not exempted from personal appearance in the court? Option A, Minister of Union. Option B, Minister of State. Option C, Vice President of India. Option D, Chairman of Public Service Commission. Answer is option D, Chairman of Public Service Commission. Next one. Inherent powers conferred under Section 151 of the CPC 1908 may be exercised by option A, Supreme Court only. Option B, High Court only. Option C, District Court only. Option D, Supreme Court, High Court, District Court, as well as by any court. Answer is option D, Supreme Court, High Court, District Court, as well as any civil court. Next one. A and B sue C for recovery of rupees 1000. C has debt due to him by A alone. Here C can. Option A, set up the debt against B. Option B, set off the debt against A. Option C, set off the debt against A and B. It is B, not 13. Both. Option D, can't set off a debt due to him by alone. A alone. Answer is option D, can't set off a debt due to him by A alone. Next one. The term prescribed under section 216 of CPC 1908 means option A, prescribed by the court. Option B, prescribed by society. Option C, prescribed by rules. Option D, none of the above. Answer is option C, prescribed by rules. Next one. Under the Code of Civil Procedure 1908, for the first time, provision for compensatory cost in respect of false or vexatious claims or defenses has been made under option A, section 35 of code. Option B, section 35B of the code. Option C, section 35A of the code. Option D, section 34 of the code. Answer is option C, section 35A of the code. A deposit a box of jewel with B as his agent. C allies that the jewel were wrongly obtained by A from him and claims them from B. Here B, option A, can institute interpolator suit against A. Option B, can institute interpolator suit against C. Option C, can constitute interpolator suit against A and C both. Option D, can't institute an interpolator suit against A and C. Answer is option D, can't institute an interpleader suit against A and C. Point out the wrong statement. Option A, where the defendant appears and the plaintiff does not appear. When the suit is called for hearing, the court shall dismiss the suit and plaintiff shall be barred from filing a fresh suit on the same cause of action. Option B, no appeal may lie from an original decree passed ex parte. Option C, the plaintiff may apply to the court which passed an ex parte decree against him for an order to set it aside. Option D, not court shall set aside a decree passed ex parte merely on the ground that there has been an irregularity in the service of someone upon the defendant. Answer is option B. No appeal may lie from an original decree passed ex parte. Under CPC 1908, even suit shall be instituted by presenting a plaint in duplicate to the court or such officer as it appoints in this behalf. This is provided under option A, section 26. Option B, section 20. Option C, order 3, rule first. Option D, order 4, rule first. Answer is option 4, rule first. Next one. Which one of the following is not a decree under CPC 1908. Option A, rejection of a plaint for non-payment of court fee. Option B, any order of dismissal for default. Option C, both A and B. Option D, none of the above. Answer is option B, any order of dismissal for default. Next one. Under the Code of Civil Procedure 1908, objection to jurisdiction as to the place of suing shall not be allowed by any appellate or revisional court unless such objection was taken. Option A, in the court of first instance. Option B, at the earliest possible opportunity. Option C, and there has been a consequent failure of justice. Option D, when all the conditions of A, B, and C are fulfilled. Answer is option D, when all the conditions of A, B, and C are fulfilled. Next one. The nature of revision under the CPC is that option A, it operates as a stay of proceedings. Option B, it operates as a stay of suit. Option C, it operates as a stay of proceedings suit and suit both. Option D, it shall not operate as a stay of suit or proceedings except where such suit or proceeding is stayed by the High Court. Answer is option D,